to another scintillating event with the Texas Federalist Society. We have a real treat for you tonight. We're hosting the Honorable Don Willett from the Fifth Circuit right here in Austin. But before I introduce our honored guest, there are a couple of things I'd like to bring to your attention. First things first, mark your calendars for next Thursday evening. We're featuring yet another originalist versus originalist debate between Josh Craddock of the James Wilson Institute and Ed Whalen of the Ethics and Public Policy Center. This debate will be about whether the 14th Amendment affirmatively prohibits abortion by constitutionalizing a right to life. So be sure to bring all your ACS friends next week. Don't worry, Judge Willett, we will not be asking you to weigh in on the matter because perhaps it will come up in front of a court. So we'll drop a registration link in the chat at some point this evening, so be looking for that. Now on to the second and more important thing. I'd like to briefly share some news about the future of our chapter. Last week, Paige Scobie, pictured here, was selected as the incoming 2021-2022 president of the Texas Federalist Society. Paige comes to UT Law as a transplant from Wisconsin. We will not hold that against her. Before law school, she worked as a lobbyist, advocating for legal and regulatory reform in the Wisconsin State Legislature. She also served in a leadership role in the Madison Lawyers chapter, and I'm confident that Paige will do an excellent job steering the chapter next year and returning us to, hopefully, in-person functions so that we can have something like this with you, Judge Willett, in person next time. So I will send a full introduction of Paige to the chapter writ large this evening, but I know that she has a few words she'd like to say about officer board applications now. So Paige, take it away.
Thanks, Seth. It's really great to be here tonight, especially when we have such an amazing speaker like Judge Willett. I'm really excited to be your president next year. The Federalist Society has been really important to me in my career and at UT, so I'm really looking forward to continuing to provide all the opportunities that Federalist Society has provided to me and make our chapter even better next year. And on that note, I'll be sending out next year's officer board applications tomorrow morning, so please look out for that in your inbox, and I hope that many of you will apply. Thank you.
All right, thank you, Paige. So now on to the matter at hand. To many of you, Judge Don Willett needs no introduction. I will, however, give it my best shot. Before joining the federal judiciary, Judge Willett served a dozen years on the Supreme Court of Texas. He has devoted his professional life to public service. Prior to becoming a judge, he served as, and let me take in a deep breath, legal counsel to the Texas Attorney General, to a Texas governor, to the U.S. Attorney General, and to the President of the United States. He was raised by a widowed mom in a double-wide trailer in a town of 32 people, and he became his family's first college graduate when he earned a triple major from Baylor University, and then 3 degrees from Duke University, a JD with honors, a Master's of Arts in Political Science, and an LLM in Judicial Studies. After law school, he clerked for the Honorable Jerry S. Williams on the Fifth Circuit, and then practiced law at Haynes and Boone before entering public service. He is a senior lecturing fellow at Duke University School of Law, and according to the FedSoc bio, he will soon be the jurist in residence at the J. Reuben Clark School at BYU. I wasn't sure how soon that was, so I wasn't sure whether that is accurate information. He is the former editor-in-chief of Judicature, the scholarly journal for judges, and has been honored 4 years in a row for exemplary legal writing, which we will discuss in a bit. He is a member of the American Law Institute, a life fellow of the American, Texas, and Austin Bar Foundations. He's a native Texan, a former rodeo bull rider and professional drummer. And in 2015, he was named the, quote, Tweeter Laureate of Texas. He and his radiant wife, Tiffany, are the exhausted co-founders of 3, quote, We Willets. So that is quite the career. We are looking forward to diving into that. And we're just so grateful to have you, Judge.
Hey, Seth, I'm delighted to be here. Thanks for having me.
Cool. So just so everybody understands what we're going to do, we have a set of questions that I'm going to ask the judge, things that I had on my mind and hope that he will answer for us. And if we have any extra time at the end, we will open it up for audience questions as well. But we'll just make that a play-by-play decision at the end. So I'm going to go ahead and get us started. You've had a varied legal career, Judge. You've been a law clerk on the court that you now serve on. We took you down that laundry list of items in the bio that you've done. And as I said, you've also been a rodeo bull rider and a professional drummer. What has been your favorite job in the law and outside of the law?
I gotta say, my rodeo days were during my early teens. I rode bulls and I rode bareback horses, and I didn't do it very long, just a couple of seasons. And I probably spent more time sort of hurtling through the air than I actually did riding on the back of these angry beasts. But my rodeo days, I think, did probably surprisingly instill some lessons that are oddly relevant to my current job. Number one, you got to hold on tight. And life, both personally and professionally, is unpredictable. It is chock full of serendipity and unexpected twists and turns and divine happenstance. And so when things do go your way, don't gloat about it. And when they don't go your way, don't wallow about it. I also played drums in cover bands and bars and clubs around Dallas when I was younger. I've worked at a video arcade. I worked at a putt-putt, worked at a gas station. I taught an LSAT prep course, lifeguarded, waited tables at Steak and Dale. But inside the law, I think my journey has been admittedly pretty roundabout, admittedly fairly unorthodox. I've been really fortunate to do all the things that you listed. And I think that varied experience has really bestowed a key virtue. I mean, having worked in and around all three branches of government on both the state and federal level, I think as a result of that, I know policymaking and I know judging and I know the difference. And I think we're all a product of our professional and our personal backgrounds. And so I think my service in government, state level, federal level, different branches, I think it makes me maybe a little more attentive to architectural building block issues like separation of powers, those sort of fundamental, elemental principles. On a multi-member appellate court, we really thrive on vigorous intra-court debate, a lot of rhetorical back and forth and hurly-burly give and take. And I think it sharpens our work to have people that are drawn from kind of eclectic professional backgrounds. I think occupational variety on a collegial multi-member court really sharpens our work. And I think there's actually a pretty strong body of empirical data that backs that up about how career diversity on a collegial court really helps produce more refined and sharpened thinking and opinions. So I have worn a lot of legal hats. I think my current one fits me best. I think I am sort of metabolically hardwired, engineered for this cloistered, contemplative, relatively nerdy and monastic life of appellate judging. I can imagine a lot of legal jobs that pay more, but I can't really think of any that to me could be any more rewarding than what I do. And it really is a magic combination to love what you do and believe that it really matters in a grand, divine, big picture sort of way. So I revere the law, and I think it's a majestic thing. And I think when we, the people, confer that title on somebody, judge or justice, you're placing that profound majesty in human hands. And judging is a really noble enterprise, and it's something that really impacts the life of every single American. So I'm really mighty extravagantly blessed, to do what I do.
Cool. That's really cool. So I think we mentioned that before you were a Fifth Circuit judge, you were a justice on the Supreme Court of Texas. So you've worn the judge hat and the justice hat at times. I bet it's probably nice not to have to think about re-election. We just talked about that in federal court. But I was just curious what your favorite opinion, now we didn't actually specify, so I'm gonna go ahead and specify that you wrote, favorite opinion that you wrote from your time on the Supreme Court of Texas, and then from your time so far on the Fifth Circuit.
You mentioned the election point, and I do miss parts of campaign life. I miss the meeting people part. I miss the interpersonal part. I miss intersecting with a really neat cross-section of people from every corner of the state. And I think there's something beneficial about nudging high court judges who kind of occupy this somewhat rarefied, insulated bubble to kind of force them to kind of descend and hang out with a really neat collection of folks. But it was the relentless money chase, the kind of round the clock, inelegant, and elegance, the most G-rated word I can probably think of. So I love the civic education part of campaign life and acquainting people with the work of the court and kind of demystifying and humanizing what judges do. But the relentless money chase was not a fun component. So I'm glad to have the political stuff kind of in my rearview mirror. And there's something to be said about life tenure. Though my daughter, who is 11 years old, she reminds me that, Daddy, the Constitution, it never uses the word life tenure. It says you serve during good behavior. And so she's always cracking the whip on me. Favorite opinion. So for my former court, probably the most memorable opinion is Strickland v. Medlin. So if y'all have trouble nodding off tonight, Google Strickland v. Medlin, M-E-D-L-E-N. Came out in 2013. And it was about what kind of damages can a grieving, like heartbroken dog owner recover if their pet is accidentally euthanized. And it was a heartbreaking case. And you know, a lot of people don't know this, but at my former court, authorship is not determined by the Chief Justice. You know, at the U.S. Supreme Court, you know, Chief Roberts, if he's in the majority, he'll decide who's going to write on behalf of the court. At my former court, it is literally the luck of the draw. It's completely egalitarian. And maybe a month or two before oral argument, the den mother at my former court, Nadine Schneider, she will take these little 3x5 blue index cards, and she'll write the names of the cases we're about to hear argument in a month or two. And then she'll fan them out like a magician, playing a card trick. And then she'll start with the junior most member of the court, and you just kind of close your eyes and use the force. And you pick a card, and that is your case. And some days the force is with you, and some days not. With Strickland v. Medlin, the force was definitely not with me. And I knew instantly this was going to be part of my judicial legacy, for better or worse. So because I knew it was going to be high profile, I wrote every word of it myself. I often give my clerks first crack at drafting stuff, but that one I wrote every word of myself. And so you're at the podium as the advocate, and somebody up there has already been assigned authorship of the opinion. You don't know who, and you may try to divine it by maybe how inquisitive they are, or maybe any kind of record-intensive questions they kind of hammer you with. But I wrote every word of that one, and it got voted out in the very first conference. It was unanimous. And we kind of stuck with our heartless precedent that in the eyes of the law, pets are personal property. And with personal property, if it's negligently destroyed, you get economic value, market value, replacement value. You don't get pain and suffering. You don't get wrongful death type sentimental damages, loss of companionship, you know, what something meant to you emotionally. And that case got more attention internationally than anything. And I wrote opinions in multi-billion-dollar market-moving disputes. But it was that one about poor Avery in Fort Worth, who escaped after a late-night thunderstorm and was mistakenly euthanized. That one is probably one I'm most known for, well, one of, on my former court. Of course, the eyebrow-threading opinion, Patel, which was a concurrence, actually. That was fun. I wrote every word of Patel myself. I knew that one, too, would be kind of one of those enduring legacy opinions. And I think I prefer separate. I love to write separately. I don't do it just for the fun of it. I only do it when I think I really need to. But it is a little more fun. You have a little more autonomy, a little more kind of stylistic latitude. You don't have to play Mother May I with, well, on my former court, 8 other very smart, willful, opinionated people who want to sandpaper your work. So under separate writings, Patel is memorable. There was a concurrence I wrote in a case involving former Chancellor McCraven. That was 2017, and that was a fun one. So Google that one later tonight. Again, if it's a surefire cure for insomnia. So Google those. Strickland v. Medlin, McCraven, McRaven, Patel. There was a dissentol. I only wrote maybe 2 or 3 dissentols on my former court, where we declined to review a case. One was a civil asset forfeiture case involving a Chevrolet truck. And another was, I forget the caption, but there are some Ferris Bueller references in the opinion. So you can Google Willett and Ferris Bueller. And that was a case about who qualifies as a member of the electronic media under Texas law. So a really interesting question that my court ducked, and I thought they should have granted it and decided it. So those are fun. My current court, my very first majority opinion was a case called Maturino, Maturino. It was a sentencing appeal about hand grenades. It was an explosive case. And it was about what length sentence would be appropriate if the guy was trying to buy 144 live grenades, but he was buying from an undercover ATF agent and only one of them was live and 143 were inert. So should it be sentenced on the one that was actually a live weapon or the 144 he thought he was buying? So that was a fun one. Zadeh, Z-A-D-E-H, and some of my kind of qualified immunity writings are interesting. And then we had a COVID-related church opening case last year out of Mississippi, a church in Holly Springs, Mississippi. So the city had some pretty severe restrictions on in-person gatherings got loosened. And at the end of all the loosening, only churches were still subject to the restrictions on in-person gathering. And the week the case was pending before my court, the church was destroyed in an arson fire. And the city, and this is all in the public record, and I kind of expressed my lack of amusement, but the city argued that when the church went up in smoke, so did their claim against the city, that because there was no church building, necessarily the appeal was mooted. And I thought that was a fanciful argument that, when these parishioners leave their homes on Sunday, they're not going to church, they are the church. And a church is not a building you go to, it's really more of a family you belong to, and it's more about people and not steeple. And so those were fun.
It's almost as if our government doesn't understand religion. Anyway, we can strike that from the record. So you mentioned writing concurrences and dissents. So I'm just going to toss a question out for you. Justice Scalia used to say that he wrote his dissents for law students. So when you're writing a concurrence or a dissent, who is your target audience and why?
Well, first, let me make a point that may surprise a lot of people. Appellate judging, federal appellate judging, it's a pretty collegial enterprise. And the dominant impulse is consensus. And I wouldn't be surprised if the number is probably 95% or more, who knows, of our opinions are 3-0. And that holds true regardless of kind of the ideological mix of the panel. So the overwhelming bulk, the lion's share of all of our opinions, 90+% are 3-0. And separate writings are really the exception and they're not the rule. But my role is not just to decide cases, it's to decide them correctly as best I can. And if I do believe that my colleagues have reached kind of the wrong answer, or maybe even the right answer, but for the wrong reason, then I may conclude that I have a duty to write separately. And maybe not every single time that I have a quibble, not every single time I want to get something off my chest. And I think sometimes you really need to kind of suffer in silence, because being a chronic dissenter who simply must always be heard on every disagreement, however trivial, I think weakens your voice over time. So I think you have to pick your battles. And I think disagreements that are respectfully explained really does enhance the prestige of courts, that it shows that judges are earnestly grappling with thorny issues in a principled way. As far as audiences, I think a judge may have multiple audiences in mind. I know I do. My colleagues on the panel are the most immediate audience. Maybe I'll change their mind, or maybe my writing will kind of sharpen or maybe improve the majority opinion. I know when I'm writing the majority and someone dissents, it certainly helps refine my analysis and response. Or maybe I can do some damage control and emphasize the limits of the majority opinion, maybe send a warning flare to other circuits. Or I could call for reform, as I've done with some of my qualified immunity opinions, where I try to point out maybe workability problems with certain doctrine. My audience may also be the broader legal community, maybe the larger public, it may be other branches of government, it may be the Supreme Court. Or it may be, sometimes it is my colleagues who weren't on the 3-judge panel, but who may be persuaded to vote in favor of rehearing that case en banc before our entire 17-member court. So the audience kind of varies from case to case, and there may be multiple audiences at any given time.
I know in that last example you gave, there's a pretty prominent opinion of yours that was in dissent that fomented a on rehearing en banc, but I know that's before the court right now, so I won't ask you to comment any further. But I totally see how that so I'm gonna ask you another substantive question based on something that you mentioned when you were talking about your colleagues on the Texas Supreme Court. You said they ducked the issue, and you thought that they should have taken it and made some merits decisions. That's kind of quintessentially Judge Willett, from my perception of you as a law student. You've been associated with the theory of judging called judicial engagement. Can you describe what you mean by that and how that theory contrasts with standard kind of Borkian calls for judicial restraint?
Sure. And of course, when I said ducking, I was being lighthearted, just a gentle, kind of jovial, tongue-in-cheek kind of jab at my former colleagues. So yeah, this association I guess I have with judicial engagement stems from the rather noisy concurrence I wrote on my former court in a case called Patel, the eyebrow threading case, which some of you may know was a state constitutional challenge to an occupational licensing regime covering eyebrow threading. Now, as Seth knows, there are multiple ways that you can shape your eyebrows. You can have them waxed, I guess, or there's this South Asian or maybe Indian technique of using these little threads and polyester cotton thread. And these technicians are like these lightning quick ninja with these strands of thread, and they just mow down all your unwanted or superfluous eyebrow hairs. And I confess I was not well acquainted with eyebrow threading before Patel. So in 1984, Justice Scalia, who was then a judge on the DC Circuit, he famously debated Professor Epstein, Richard Epstein, on judicial protections for economic liberty. And Justice Scalia, or Judge Scalia, then argued for greater restraint on the part of judges. And Epstein, unsurprisingly, took the contrary view. And as I wrote in my Patel opinion, and Patel took a long time to be decided. It landed at the court. The petition was filed in 2012, and it wasn't decided until the middle of 2015. So it lingered for a long time. And even after we granted it, I had no confidence. I had no idea how it was going to turn out. But as I wrote in Patel, there's this raucous debate in legal circles over when it's proper for judges to strike down legislative or executive action as unconstitutional. And I believe judicial duty requires judges to behave judicially by adjudicating and not politically by legislating. And I also understand, I think, consummately, that the law is not wet clay that a willful judge can mold into whatever outcome that he or she finds most ideologically congenial or satisfying. Judicial excellence does require judicial deference to the policymaking branches. And my job as a judge is to interpret laws, not to be a super legislature, not to impose my fiat, by fiat of, whatever, strongly held political preference I may have. And just because something strikes me as right doesn't mean it's constitutionally mandated. And it doesn't mean that I'm, to deliver victories on quintessential policy questions to preferred groups or causes. So bottom line, I say all that kind of as preface. My supreme allegiance is, to the Constitution. And the political branches decide if laws pass. But judges decide if laws pass muster. And if a liberty that's enshrined in our Constitution is imperiled, then I do think that excessive permissiveness doesn't really have a place. Now, there's no doubt that lawmakers, their prerogative when it comes to policymaking is unrivaled. But that doesn't mean that it's carte blanche to regulate all spheres of everyday life to the extreme. And they're preeminent when it comes to policy, but preeminence doesn't mean omnipotence. And there have to remain judicially enforceable constraints on legislative action that may be irreconcilable with constitutional commands. So, and I think if judges aren't duly engaged, for lack of a better word, I think deference can devolve into dereliction. I think adjudication can more resemble abdication. And the judiciary, we're a constitutional partner, and we're not a junior partner. We're kind of full in. And I think judges should always be respectful of the political branches, but we should never be beholden to them. So judicial activism is real, inventing rights that aren't anywhere in the Constitution. But judicial passivism is also real, which is kind of disregarding the rights that are actually enshrined in the Constitution. So, in some ways, this charge of judicial activism, it has a real slipperiness to it. Justice Kennedy said it really depended on, whose ox was being gored. And I think he famously said, an activist court is a court that makes a decision that you don't like. And lawyers rhetorically will often argue, my opponent's argument is an invitation to engage in judicial activism. And the other side will often make the identical charge back the other way. So these labels, these kind of pejoratives, judicial activist or whatever, to to some degree, it's kind of a legal Rorschach test, like an ink blot test, and people see different things. So as I wrote in Patel, I oppose judicial activism, inventing rights that aren't rooted in the law. But the opposite extreme, that judicial passivism, is corrosive too. So judges who perhaps, not activist are also maybe not properly active in preserving the liberties and the limits that our framers actually put in place, that they actually enshrined. So in Patel, it's really important to remember we were interpreting the Texas Constitution. The Texas Constitution is irrefutably framed in proscription. It imposes very unsubtle, very unmistakable limits on government power. And it models the federal Constitution in a fundamental way. It divides power so that every branch kind of checks and balances the other branches. And as a judge, we don't have any business second guessing the policy choices of lawmakers. But when constitutional rights that have actually been enshrined are threatened or imperiled, it's not impolite to say no to government. It's our duty. And I think judicial restraint doesn't require us to sort of give a pass to the non-restraint of other branches. And I think that's precisely why the Constitution was written, was to keep government on a leash. And, I expected to be cross-examined at my confirmation hearing about Patel, but I didn't get a single question about it. But what I was going to say in a nutshell is this, Patel was a really loud reminder that not all constitutional law comes from the federal Constitution. America doesn't have one constitution. America has 51 constitutions. And if you haven't read Judge Sutton's really exceptional book, 51 Imperfect Solutions, I urge everybody to read it. It really does a masterful job at describing the underestimated role of the states in crafting our constitutional landscape. But we do live in a compound republic, and that's a bedrock tenet of federalism. Power is not concentrated in DC. It is separated vertically, better to ensure and secure liberty. And American constitutionalism is about a heck of a lot more than what happened in Philadelphia 234 years ago. It's also about what happens in state capitals, from sea to shining sea. And my court, my former court, the Texas Supreme Court, that court is the ultimate arbiter of what the Texas Constitution means. So Patel had nothing to do with the US Constitution, nothing to do with the 14th Amendment, had everything to do with Article 1, Section 19 of the Texas Constitution, which is part of our Bill of Rights. And also that provision was enacted only 2 short years after Slaughterhouse, where the Supreme Court declared that states possess the power to protect their citizens' privileges and immunities, including the right to earn a living. So Slaughterhouse came out just 2 short years before our constitutional provision was adopted. And so in short, my court was interpreting the state constitution, which was enacted by different people at a different time with different priorities and a different history and using different language. And there are some states who do kind of march in lockstep and interpret their state constitution in lockstep with the federal constitution, but Texas is not one of them. And Texas, like every other state, is absolutely free to add to the liberties of her citizens. And Texas has done so. And a lot of other states do so too in different contexts. I mean, long before Heller, the Second Amendment case, there were 39 state judiciaries that had already interpreted their state constitutional provision to say individuals have a right to keep and bear arms. After Employment Division v. Smith, which came out 30 years ago, 1990, a dozen state Supreme Courts held that their state constitutions provide greater protection for the free exercise of religion. So again, American constitutionalism is about a heck of a lot more than what happens in DC. And America's got not one, but 51 constitutions.
Thankfully so. So I know you said, we talked about Justice Scalia writing his dissents for law students. I just want you to know that there's at least one law student at the University of Texas who came to law school because of your concurrence in Patel. So the undocumented effect, he may or may not be here this evening. So shout out to him.
Amazing.
So I'm gonna switch gears a little bit and ask you this. You were on the original Supreme Court shortlist that then candidate Donald Trump issued in May 2016. So what was that? What was that moment like? Did you get a heads up? And how did you end up learning that you were on the list?
What was that moment like? It was like, it was an out of body experience. So, and the news broke. I got no heads up whatsoever. And a few other groups like Heritage Foundation and others had put out their own sort of short lists prior to this. And candidate Trump had promised to put out one himself, and I had no idea if I would be on his list or not. But there was no heads up. And if I had gotten a heads up, I sure wouldn't have been kind of where I was at the time the news broke. So the news broke at the worst possible time, in the worst possible place. So I had just devoured some tasty barbecue at La Barbecue in East Austin. I was with my good friend, whose Twitter handle is Iowa Hawk Blog, which some of you may follow. So he and I and our friend Jess Pryles had just gotten some decadent barbecue at La Barbecue. So then I had my buddy drop me off downtown at Governor Abbott's book signing. Governor Abbott had written a book, and this was the kickoff, the inaugural stop on his book tour. And so that's where I was when the announcement occurred. And I arrived about 15, 20 minutes late. And the auditorium is like sardine packed, vacuum packed. And there's a staffer who said, "Hey, Judge, I think there's one more seat down here at the end of this row. Why don't you scoot on down and take it?" So I kind of scooted by people, pardon me. And Governor Abbott kind of saw me kind of scooting past people, and he paused and he said, I forget what he said. It was something really gracious and kind. I think the school finance opinion that I authored had just come out, and people applauded, and I waved sheepishly and sat down. So everybody sort of knew that I was there and where I was. And then as I sat down, my phone in my pocket began to buzz, and I fished it out, and it was lit up like a Vegas slot machine, and with texts and news alerts and everything else. And I had about 30 seconds to kind of process what had happened. So I kind of pieced together these fragments of text alerts and this and that. And I finally put two and two together and figured out that the list had been published and somehow I was on it. And I had about 30 seconds to process all this. And then I remember looking up from my phone to kind of find myself surrounded by the entire Texas Capitol press corps. I was immediately swarmed by this polite but very persistent press corps who couldn't believe their luck that the news broke with me just a few feet away. And they all got the news when I got the news and made a beeline directly to me. And they just surrounded me with cameras, and people were taking video on their iPhones. And I was pretty dumbstruck. And I think they were all pretty amused at my sort of thunderstruck kind of judge in the headlights reaction. And I think one reporter described me as sweetly flustered is the description that he used. And I could not even muster kind of a tweet length response. And I finally, my brain cells were not, my synapses were not firing very well. But I finally muttered something about needing to exercise some judicial restraint at that moment. And I skedaddled and got out of there. And I made a beeline for my office, called my wife on the way to tell her the news. And then I turned on the TV in my chambers to find Jake Tapper kind of scrolling through my Twitter feed, kind of laughing and making jokes at my expense. And then that night, Jimmy Kimmel is reading my tweets during his monologue. And it was a surreal kind of out of body experience. I gained about 10,000 new Twitter followers that day, which is kind of mind boggling. But it really was kind of otherworldly to be listed alongside that original list. There were 11 total. But I knew most and certainly respected all of the other judges on that list. And being named alongside them for any purpose was really a rich honor. And they were exceptional jurists, and they remain exceptional jurists. And importantly, I thought it was interesting at the time that more than half of them, I think 6 out of the 11, either had served or were serving in the state judiciary, where the overwhelming bulk of American justice is dispensed. And I certainly thought politically the announcement by then candidate Trump was a really masterful kind of genius political move. It certainly raised awareness of the obscure judicial branch, which I think is a noble civic good. The judiciary, it really flexes profound power over the lives of everyday folks. And in my view, it doesn't get nearly enough attention from presidential candidates. And I frankly think White House contenders should talk more about the judicial branch and about what they view as its proper constitutional role.
Well, I think everybody can agree, and we don't have to go into the Twitter stuff too far, but the biggest casualty of your, well, I won't even say elevation's not the appropriate word. Your lateral move over to the federal judiciary is the no more tweeting.
Yeah, well, I do think my current gig is a lateral move at best. I certainly don't view it as a promotion. But Twitter, it began as a political communications tool. I had to run for office, and judges, their name ID hovers between infinitesimal and zilch. And anything you do to kind of tattoo your name onto the noggins of voters, kind of embed your name in a little tiny crevice in the short-term memory of voters. So anything you can do to remove distance and build awareness and raise visibility. And I think people were kind of genuinely astonished that a fuddy-duddy judge, and I'm as fuddy-duddy as they come. I mean, my geekery is on an uber elite level, but people were just floored that this fuddy-duddy jurist could kind of step out from behind the bench and come across as halfway ordinary or engaging. But I tried to keep it light, and I tried to stay above the fray. But my goal was really to kind of demystify and humanize this often inscrutable branch of government. I think my all-time cap in terms of followers was about 125,000. Then I went dark when my federal nomination happened. And then I came back for about 2 or 3 weeks after I was confirmed, but before I took my federal oath. And then my last tweet was New Year's Day, 2018, because I took my federal oath the following day. And, appellate judging is an intensely, collegial enterprise. And I want to be an effective member of my court. And there's a big generational spectrum on my court. People from their 40s all the way. Judge Reevely just passed away at age 99. Mm-hmm. So I didn't want to do anything that might unwittingly or inadvertently kind of hamper my effectiveness as a member of the court. It does remain my primary news feed. And I'm lurking every day. I'm a lurker now. And I still see frequently old tweets of mine that for some reason have been retweeted or have gained kind of new life. And that's kind of funny. I'll get a spurt of new followers, but every day I hemorrhage probably 50 or so followers. I'm down to a paltry 90,000 or something. But I've left it up kind of as a historical archive. There's some federal judges who have totally kind of unplugged and taken down their Twitter account. And for better or worse, I've left mine up as sort of an archive and just so people can have it to scroll through if they might want to do that for some crazy reason. But I miss it. And I get an itchy Twitter finger sometimes, but it really is a burden lifted not to have to devote kind of time and energy to it. It really did require a lot of care and feeding to come up with content. But I'm on there every day. I'm lurking, and it's how I stay abreast of all the warp speed happenings in the world.
Well, it's good to know. Funny enough, I will just brief story. Professor Vladeck is a lot of our federal courts professors this semester, and he said something to that effect today. He said that there were some notable appellate court judges that are lurkers on Twitter, and maybe they saw his Twitter feed. So he may have been talking about you today. I don't know. But I have another question about the Trump list. Obviously, that list is quite diverse. I mean, a lot of people on that list share a lot in common, but there's also some pretty subtle but important disagreements within the conservative legal movement. So how do you approach the differences? How do you approach legal language? And how should we talked a little bit about your judicial philosophy, but how should judges approach that task?
You mentioned kind of, Trump judges or whatever, I forget how you phrased it, but there was kind of this silly view that so-called Trump judges, that we all march in ideological lockstep. But I think the facts are fairly hostile witnesses. And, Federalist 20, I love this quote. Federalist 20 says, "Experience is the oracle of truth." And the real world truth is that Trump appointees have engaged in some pretty spirited, no holds barred legal debates in their opinions. And sometimes we nod heads, but often we butt heads. And I think one of the maybe most vivid examples concerns qualified immunity. Kind of, this judge invented doctrine that shields government officials from being sued when they violate somebody's constitutional rights, so long as that violation wasn't, quote, clearly established. And there is kind of this growing cross-ideological chorus of judges and scholars that are urging the Supreme Court to recalibrate, to rethink the current immunity regime, because critics do believe that it does allow untold constitutional violations to kind of slip through unchecked. And I'm one of those judges who has urged refinements of the QI doctrine. And I think I've written that, qualified immunity often smacks of unqualified impunity. And I've butted heads with some of my fellow new appointees over the real world functioning of the modern immunity practice, which I've described as essentially heads government wins, tails plaintiffs lose, where wrongs are not righted, people are left violated but not vindicated. And I don't think that immunity ought to be immune from smart refinements that more fairly achieve kind of the intended goals of the doctrine. And as far as how I approach legal language, I'm a resolute textualist. I'm all about giving words their soundest and most honest and most forthright reading. The lion's share of modern day appellate judging is not about imposing a result we find ideologically ideologically satisfying or congenial or fair or equitable. As first-year lawyers, in torts or contracts or property, you read all these common law opinions written by these legal lions like Learned Hand and Benjamin Cardozo and all these folks who at the time were state law jurists, state common law judges who were really kind of fashioning the law case by case, imposing a result they found most equitable. But we don't live in that legal world anymore. And lawmakers are fond of lawmaking. And every new statute, every new regulation, every new executive order that comes onto the books, it kind of shrinks steadily that universe of freewheeling common law judging. And 21st century appellate judging is mostly spent reading words on a computer screen and deciding what they mean. And again, I'm a diehard textualist, but textualism is not literalism. And sometimes people falsely equate the two. I aim to read language commonsensibly, discerning it, not distorting it. And I'm all about giving words their more, the most forthright, kind of straight ahead reading I can. And I think judges have to have scrupulous fidelity to text and not give words just a bearable interpretation, but the best interpretation, the most legally plausible interpretation. And I think interpretive context is everything. And your reading has to be rooted, has to be anchored in textual and structural and linguistic and semantic evidence. And all that said, words are slippery. And even good faith, textualists can and do read text differently. So textualists don't all agree on everything. And we recently saw a fairly high profile example of that at the Supreme Court in the case about whether federal anti-discrimination law as drafted 56, 57 years ago, does it cover sexual orientation? Does it cover gender identity? And you have textualists on the court who came to polar opposite conclusions. So it was heartening that both sides purported to apply textual analysis. But again, as we know, they reached diametrically opposed conclusions.
Well, I did put, for those interested, I put Judge Willett's views on qualified immunity and Zadeh in the chat. And then I was trying to do a quick Google search, but I think most prominent source of disagreement would have been Judge Ho's and Judge Oldham's concurring. Was it a concurrence or a dissent? I forget. Either way, I didn't remember the name of the case.
I can't remember the caption either, but yeah, it was feisty. It was. Not personal. And I love those guys, and they're a tremendous jurist. But we're all kind of doing the best we can. But again, we don't see every nuance of every case the same way. And that's why we serve in 3-judge panels, because we have this view that iron sharpens iron, and bouncing legal views off each other kind of sharpens and refines our work.
All right. Well, we only have a couple minutes left, so I'm going to do a couple of rapid fire questions here.
Yeah.
First, if you could have dinner with any SCOTUS justice not currently on the court, so I guess that means either dead or alive, not currently on the court,
okay.
Who would it be?
I don't think. So I've been asked this question before, and it's got to be, to me, John Marshall Harlan. Not okay. John Marshall,
Harlan.
Not the second Justice Harlan, John Marshall Harlan, the first Justice Harlan, the great dissenter, as he was known. And I think we would talk about, he has an incredible backstory. So we would talk about, I would quiz him about redemption. I would quiz him about judicial courage. So as you probably know, Justice Harlan, he wrote the famous and at the time lonely, but later vindicated dissent in Plessy. And he championed equality. He championed human dignity and racial justice on what was at the time a pretty hostile Supreme Court. And I learned recently that he had a half brother. He likely had a half brother who was a freed slave, which I did not know until recently. But before all that, and even before all that, he had fought for the Union in the Civil War. But before that, he was a slave owner, just as Harlan was. And he was an opponent in his prejudged life of the Reconstruction Amendments. But something happened in his life and he changed. And he famously said, "I'd rather be right than consistent." And so in case after case, when he was on the court, the Supreme Court refused to interfere with the South's hostility to civil rights for former slaves. And Harlan was a vocal and very lonely dissenter. So I was so impressed with Justice Harlan that, and we have a new puppy in our house whose name is Amicus. We gave him the Texas pronunciation, not amicus, but amicus. And his middle name is Harlan, after the great dissenter. And here, I'll pull up a photo on my phone and show it to my camera, and y'all can see young Amicus. You see that little guy? Oh no.
It's not coming through.
Oh, that's a bummer. There he is. Oh,
I got a flash. Yeah. What breed?
He is kind of a mix. He's part Cavalier, King Charles Spaniel, and part Bichon. So
okay. Yeah, we have a Maltese poodle mix at the Smitherman house. So anyway, I had some other questions, but I honestly feel like that's a pretty good place to leave it. We saw a picture of Judge Willett's dog. I think that we know Judge Willett, the man and judge. We're really grateful for your time, Judge. This has been a lot of fun. I wish we could stay around longer and ask a couple of the audience questions, because I'm sure they'd be good. But from what I heard at the beginning of the call, you have a late night.
No, I'm happy to field a couple if y'all want to fire them my way.
Well, I think that there was one question that is a bit substantive, coming from Henry Humphreys. He says, in Heckman versus Williamson County, you, writing for the court, reaffirmed that the Texas standing test parallels the federal test. Given that the Texas judiciary is at least more accountable to Texans, shouldn't Texas courts have a more permissible standing test?
Oh gosh, I have not thought about that case since I kind of signed the hard copy and sent it to the clerk's office. I've got certain colleagues who are total savants, and they have this encyclopedic and microscopic recall of everything they've written and said and heard. And I confess I'm not one. And as soon as I'm done with the case, I kind of do some mental housekeeping and kind of clear out some mental hard drive to make room for new stuff. So I've got the foggiest recollection of that case, but not really enough to respond all that helpfully. So I'm sorry about that.
That's fine. That's fine. Henry will have to save his question for another time.
Sorry, Henry.
So another question from Austin Nelson. This is probably one that you do have opinions on. I don't know if you will comment or not. Earlier this month, the Biden administration announced that it will follow the Trump administration and will not consult the ABA on prospective judicial nominees. In your own experience and opinion, is the ABA well qualified to evaluate the president's nominees for the federal judiciary?
I have always been curious why administrations felt compelled to sort of pre-announce their nominees to outside groups. And now the ABA, I will say they treated me very well. I got along famously with my vetter, who's a really prominent lawyer for Mississippi. He was a wonderful guy, consummate professional. And thankfully, I got a unanimous, well-qualified rating. So I have no complaints with with how they hit the center of the bullseye with my rating. I was really surprised when I saw the Biden administration do that, because the ABA, at least in Democratic administrations, has played a front and center role in kind of kicking the tires and vetting prospective nominees, and in some cases, kind of derailing presumed nominees where their nominations, the plug was pulled because the rating was going to be unfavorable. But I was surprised when I read that news. And perhaps this is all kind of naked speculation and conjecture. And maybe it's because the administration, maybe they're looking to kind of deepen or widen the pool from which they're drawing nominees. And it may be a pool, this broader pool may encompass lawyers from maybe uncommon practice areas compared to the types of backgrounds that currently dominate the federal bench. Now, there are a lot of prosecutors on the federal bench. There aren't a lot of public interest lawyers, not a lot of public defenders, maybe not as many academics. So they maybe in anticipation of drawing from a different pool or a wider or deeper pool of potential nominees. And maybe there's a belief that the criteria that the ABA uses might not be as kind of complementary, or it may not fit the professional background and profile of folks who go into these really important but historically overlooked areas of practice.
Yeah. Well, I do think that there are maybe a few of your, for lack of a better term, Trump-appointed colleagues who they didn't hit the bullseye quite as well on. To just leave it like that. I think those are the two questions that we had in the question and answer chat. So I think we'll go ahead and wrap up there. I did have one request of Tanner, who's working the back end of tonight's event. Would you mind promoting Kylie Kopp to speak? She had an update on our social event for tomorrow evening, and she was going to just share a couple of words on that. So thank you, Tanner.
Hi, everyone. We're really looking forward to our second FedSoc Friday tomorrow. Warner Scott has generously offered his home for a fun bonfire gathering in his backyard. And I will also be having another gathering at Central Machine Works in East Austin. So check your email for those details and text either me or Warner. Our numbers are in the email, and let us know you're coming. We're really looking forward to it.
Judge Willett will see you there.
Hey, thanks, guys. I'm going to get back to work. You get a lot of bang for your taxpayer buck with me. I'm going to be working till the wee hours prepping for argument next week, but I've thoroughly enjoyed it. Seth, thanks for your masterful sort of interrogation. I appreciate it, and wish you guys all the best. Good luck.
Of course. Thank you so much for your time, Judge, and we'll have a good evening.
Take care.